Welcome to the 11th episode of the Beyond Retirement Learning Series. I'm Susan Graham of Senior Edge Legal. I'm a certified elder law attorney based in Boise, Idaho. And what I'm going to talk to you about today is, are you over the age of 70 with no estate plan in place? And why does that really matter? I know your goal is to get useful information and to see if I might be an appropriate member for your team. But my goal is to see that you get useful information and also to provide you with free legal forms. If you want to connect with me in the future, all you need to do is fill out that evaluation form that's at the bottom of their screen. So let's get started with today's topic. Are you over the age of 70 with no estate plan in place? And again, who cares, or why does that really matter? Well, there are a number of reasons. First of all, when someone dies, the big problem becomes, how do we transfer assets? How do we move the assets, the titled assets that were in the name of the decedent, to whomever's supposed to receive them? Well, there are a couple of different ways. One is, in the state of Idaho, it's necessary to probate the estate, meaning go to court and get court participation in handling those affairs. If the decedent, the person who died, has real property, no matter what it's worth, whether it's a $5,000 bare lot or a $1 million home. And the other reason that you get pushed into the probate court is if you don't have real property, but the cumulative value of your titled assets exceed $100,000. That's CDs, RVs, that kind of thing. So maybe you don't need to deal with the probate court. There are a couple of ways to avoid that. One is, again, if there's no estate plan in place, there may have been beneficiary designations on certain assets, like certificates of deposit might be paid on death accounts or POD accounts. Same thing for some checking and savings accounts. It might be that the life insurance or retirement accounts, such as IRAs or 401ks or annuities, have beneficiary designations. So that's another way you can avoid a death probate. You just show the death certificate to whomever has that asset, and they'll distribute the money out to whoever's named as the beneficiary. If the person who died has no real property and the cumulative value of their other assets do not exceed $100,000, and there is no beneficiary designation, then it's possible to use a small estate affidavit, which is just a document that someone signs that says, gee, this person died, we're not going to probate their estate, the total value of their assets is less than $100,000, and again, you attach a certified death certificate to that affidavit and present it to whomever has that asset, and you can collect that money. You have to wait 30 days till you can actually use that, because they have to have been dead for more than 30 days. So that's what happens in terms of gathering up the assets. You either have to probate it or go through one of those other alternatives. Now the next issue is who's in charge. If there's no estate plan in place, there's no designated person or entity to take over and do the job. So the Idaho Code has a default provision. And what it says is if there's no estate plan in place, it's going to be the current spouse. And if there is no spouse, then it's going to be the heirs, the kids, the grandkids who would inherit. And we can look in the Idaho Code to see who those individuals would be. And if nobody steps up, it ultimately can become the creditor, somebody that is owed money by the decedent. The problem becomes the person or persons who step up to take that job and file that petition with the court to probate the estate. Do they really have the ability to handle it? Do they have the skills to do that properly? So that's another big problem about not having an estate plan in place. A third problem is who's going to be impacted by your death. If you have a spouse, certainly the spouse is going to be impacted. If you have minor children, that's a problem. The law says minor children get the money when they are age 18, when they're adults. Officially, they're adults at age 18 under the law. Well, you all know that most 18-year-olds are idiots. Most young people don't figure things out until their late 20s. So that's not really helpful to give significant funds to a young person. And a married couple, the surviving spouse inherits, and that's what it says under the Idaho Code. But the surviving spouse inherits 100% of the community property and only a portion of the separate property. The presumption is all of the property is community that's owned by a husband and wife, no matter how it's titled. But there's another kind of property that's owned by married people, and that's called separate property. Separate property is something that was owned before the marriage or received as a gift and inheritance to just the decedent, one spouse, during the term of the marriage. And what the law says, the default provisions in the law says, the surviving spouse gets 1/2 of the separate property. And another portion, the other portion, goes to children of the decedent or the parents of the decedent. And then there's the issue of what is separate property. Idaho says income generated from separate property is community property. That means if you have a fishbowl with white marbles, and that's all separate property, as time goes by, community property gets distributed into that fishbowl without any effort on your part. So they're black marbles that go in. What are the black marbles? Interest earned on separate property is community property. Dividends generated by separate property is community property. Rental income from separate property is community property. And then there are community property contributions to a separate property asset, such as using your wages to pay down on the mortgage on a separate property asset. That just gets to be a nightmare to try to sort that out. Another group of people that are impacted by the death of someone is the people who are dependent on you. I'm talking about not only minor children and spouses, but you may have disabled people that are dependent on you. And if they inherit money, they may lose their disability benefits or have them reduced drastically. And there may be some charities that you support regularly, a church or other nonprofits, and they too will be impacted by the failure to have an estate plan because they will receive nothing under a non-existent estate plan. The Idaho Code does not have a default provision to pick up nonprofits that you've been supporting through your lifetime. Lastly, what's the process when someone dies and they have no estate plan? How does this all work? How do we sort all this stuff out? Well, what happens is somebody needs to step up and say they'll take the job. And again, normally we need to probate that estate. So that's that individual who's going to petition the court and say, appoint me to be the one to handle everything. In Idaho, we call that person a personal representative. And there's some notice requirements and so forth, but ultimately somebody will be appointed to handle the affairs of the decedent. That individual has the responsibility to protect the assets. By that I mean change the locks on the house immediately and stop people's free access through the home where they take whatever they think they want or they think they might be entitled to, whether they are or not. So the job of that individual is to protect the assets, figure out what the bills are, ultimately pay the bills, and then lastly, distribute the assets out to the people that are entitled to it. An accounting must be provided that shows what was started with and what came in and went out in terms of the assets and what's left over and how it gets distributed. The individual handling that goes to court and asks for court approval for the distribution of the assets before they're actually made. If they don't do that and they don't get approval of the heirs, all the heirs, about what they're distributing, then the individual who has been handling this, that personal representative, has personal liability to make up the difference if in fact they've done it incorrectly. When we help people who have no estate plan, when we help the families of people who have no estate plan, instead of having the court approval at the end, usually what we try to do to save on cost and time is to give an agreement to all of the heirs as well as notify them about all of the accounting and let them know ahead of time, this is what you're going to get. Do you agree that's okay? And if everybody signs off on that, then we just give them the money. Also, it's recommended that whoever's responsible for that hold back some money. Hold back what we call a reserve for unexpected expenses and hold that back for at least a year after all the rest of the money has been distributed out, so that if there is an unexpected bill that comes through, there's sufficient monies to pay that, rather than calling up the heirs and saying, gee, send me back $752 for your share of this new bill that's come through. Because they're not going to send that to you. They probably spent it, or they think it's your problem. And it will be the problem of the personal representative if they have not received or not held back sufficient funds to pay, and the other heirs don't kick back that money. So, why would you care about not having an estate plan? There's a laundry list of reasons. If it's your goal to truly make things easy for the people behind you, if you die the day you die, or if you become seriously ill, it's terribly important to have a written estate plan that actually reflects your desires and who you want to have be in charge and who ultimately inherits from you, and any strings on the money. Like, for instance, young people, usually we say the money's managed for them until they're 30. It can be used for schooling, a down payment on a house, buying sneakers, whatever seems appropriate, but you just don't hand $200,000 to an 18-year-old because they think they've won the jackpot. They just think this is cool, and they spend the money, and then there's nothing left. Now, the next thing I want to remind you of is please complete that evaluation form at the bottom of your screen. If you want, you can indicate you'd like to visit with me, and someone in my office will follow through with you to see if we could possibly be a good fit. In addition, please critique me and let me know how I might improve, because I enjoy doing these programs for people, but I can also include topics that I hadn't thought people were interested in, or change some of my approach to how I share this information. I want to let you know that the next topic is going to be about, if you're new to Idaho, does it change your existing estate plan? Thank you.